Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Fatima Azhara binti Rosli 248612. Today, I will present to you regarding contribution of Rawl'S theory of justice. Firstly, let me introduce who is Rawl'S. Okay, so who is Rawl'S? John Rawl'S was an American political philosopher in the liberal tradition. His theory of justice as fairness described a society of free citizens holding equal basic rights and cooperating within an egalitarian economic system. Rawl'S story is oriented towards liberalism and form the basis for what law enforcement and the criminal justice system it should strive for in the pluralistic and also the liberal society. Borrowing from some concepts of social contract theory, Rawl'S envisions a society in which the principle of justice are founded in a social contract. However, Rawl'S identified problems with the social contract that do not allow fairness and equality to exist among members of society. Therefore, the purpose a social contract which is negotiated behind a veil of ignorance. Here, the negotiating participants have no idea what their race, gender, education, health, sexual orientation, and the characteristic are so that the social contract is fair. There are 4 theories contributed by John Rawl'S. The first theory made by him is the sequence of the theories. According to Rawl'S, he has no universal principle because the correct regulative principle for anything. He also says that it depends on the nature of the thing. Rawl'S confined his theory to the technical domain, and within this domain, he holds that the correct principle for each subdomain depend on its particular agents and the constraints. The second theory made by the Rawl'S is the ideal and non-ideal theory. Okay, what is ideal theory? Ideal theory make 2 types of idealizing assumption about subject matters. It is a theory assumes that all actors, which is the citizen and also the societies, generally willing to comply or to have a good work with the principle which are chosen, idealize away the positivity of law breaking either by individual in crime or by the parties, assume that reasonably favorable social condition wherein citizens and society are able to abide by principle or political cooperation. Whilst non-ideal theory is a theory that can be set out by reference to the ideal. The third contribution of the theories by Rawl'S is the reflective equilibrium. In reflective equilibrium, one specific political judgment, such as slavery is unjust, imprisonment without trial is unjust, support one's more general political conviction, such as all citizens have certain basic rights, which support one's very abstract belief about the political world. The method of reflective equilibrium can be used to get closer to it and so increase the justifiability of our belief. In carrying through this method, one begins with one's considered moral judgment, those made consistently and without hesitation when one is under good condition for thinking, such as when we change our mind that the slavery is wrong, all citizens are political equals, that one treats this considered judgment as provisional fixed points and then starts the process of bringing one's belief into relation of mutual support and explanation as described above. However, in working toward greater reflective equilibrium, the independence of moral and political theory is one type of belief that could be relevant to one's conclusion about how political institutions should be arranged. The metaphysical belief regarding free will or personal identity might be relevant because it could epistemological belief about how we come to know what moral facts there are. However, Rawls also argued in a theory in terms of justice. So, in his opinion, the primary concern of justice is fairness. As for the principal one argued by Rawls, which is everybody or each person is to have an equal right. So in this principle one, I found one case that can relate the argument made by Rawls, which is in the case of Vineta Sharma versus Rakesh Sharma 2020 in regards of the right of a daughter to have to have an equal scenery right when the father died. Okay, so in this case, in this referred case, the three judge of the Supreme Court has held that the daughters and son have an equal co-partnership right according to Hindu undivided family. So the three judges has stated the 2 points here. The first point is the co-partnership rights are acquired by daughters on their birth, and the second one is the fathers need not have been alive when the 2005 amendment of the Hindu Succession Act 1956 was passed. For the second principle, in this argument made by John Rawls, which is the social and economic inequalities can be rearranged, is we take the case happen or the situation happen in Malaysia, for example, where the UiTM students mostly come from a rich family. Although UiTM was built uh, to give the opportunity to the student who come from poor or the third class family to have an education in the future. However, the UiTM right now had been dominated by the 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 rich family, as we can see. Some of the students are from the Datuk's family or the Tan Sri's family. So this is the inequality in terms of education for me. And in terms of working environment, there would still a racism where the employer, uh, I don't want to mention the race or the name of the employer that I have met before, but I take it as a general issue for the social and economic inequality. Uh, in this working environment, there would still a racism where the employer tend to not taking other races to join their company. Uh, we need to change this environment because everyone deserve to show their talent and also show their ability to do the work. The third example is based on Asia Abdul Jalil case. So in this case, it is an injustice to a chambering student due to her attitude. This is claimed by her master, even though she had successfully finished her long call task. For me, this is not fair for a student who in a legal position that she has finished her task and also has getting her affidavit to be admitted as an advocate and solicitor, but just because of her appearance and also the attitude, her master denied her her admission as an advocate and solicitor. In my humble opinion, in regards Rawl's theory regarding the equality, I found out based on the example in the case that I mentioned before, which is the case of Vineta Sharma versus Rakesh Sharma 2020, when looking at the point of religion, for example, in Islam, a daughter is basically, according to Islamic law, only eligible to receive 2/3 of the property left by her father. In other cases of situation, when the father has died before the death of the grandfather who intend to inherit the property to his heirs or to his heirs, the daughter is not eligible to receive the property. Another example, in the case of Asya Abdul Jalil, a person who has been denied her right as an advocate and solicitor for judging through her outspoken voice when voicing an opinion by her master. In this case, I also read that while doing the chambering, she also was not allowed to attend the slots in court because she was a woman. According to according to her master, the field of criminal and litigation is only suitable for men, while women should be more likely to manage legal matters in the office. However, in the matter of social economic inequality, I think Rawls is the philosophical fighter who has opened our eyes in fighting for the right to coexistence such as education, employment and gender equality, in counteracting the mentality that a job is only suitable for someone judging by his skin color, religion and gender, rather than through talent or ability. Also, in my humble opinion, the social economic inequality like this can be changed when its backbone is changed. For example, maybe we can make a little change with the amendment of something, perhaps the law that is inequitable, so that everyone or every person can enjoy the equal rights in their lives and be able to live a life fairly and without prejudice.